Welcome, everyone, to the 2020 ASIL Practitioners Forum. If you've been attending the research forum and professional development sessions throughout the day, I hope you found them engaging. If you're just joining us now for the Practitioners Forum, welcome. The Society created the Practitioners Forum 5 years ago as a counterpart to the Research Forum, by then a well-established international event. The goal was to strengthen the Society's connections with practitioners, a goal near and dear to my heart, by fostering collaboration among scholars and practitioners seeking solutions to some of the most complex issues confronting practicing lawyers and their clients. Today's forum examines critical issues that stand at the intersection of technology, privacy, and human rights. We'll begin with keynote remarks by Professor Vivek Krishnamurthy, whose theme is Digital Technology and Human Rights, Friends or Foes? Following his remarks, our Practitioners Forum panel will discuss global issues related to arbitrating, data breaches, and privacy rights. Before I introduce our keynote speaker, I want to thank the Practitioners Forum co-chairs Christina Horaeus, Bart Smit-Dausenkunst, and Milena Stereo, all of whom spent an amazing amount of time in developing this evening's program. We greatly appreciate their efforts, and I think you're in for a treat. So that takes me to the keynote. Vivek Krishnamurthy is the Samuelson Glishko Professor of Law at the University of Ottawa and Director of the Samuelson Glishko Canadian Internet Policy and Public Interest Clinic. Vivek's teaching, scholarship, and clinical legal practice focus on the complex regulatory and human rights-related challenges that arise in cyberspace. He advises governments, activists, and companies on the human rights impacts of new technologies and is a frequent commentator on emerging technology and public policy issues. Vivek was previously the Assistant Director of Harvard Law School's Cyber Law Clinic and Counsel in the Corporate Social Responsibility Practice at Foley Hoag. He's a Rhodes Scholar and clerk for the Honorable Morris J. Fish of the Supreme Court of Canada upon his graduation from Yale Law. Vivek is currently a fellow at the Carr Center for Human Rights Policy at the Harvard Kennedy School, an affiliate of the Berkman Klein Center for Internet and Society at Harvard University, and a senior associate of the Human Rights Initiative at the Center for Strategic and International Studies in DC. We're very grateful to have him with us for this timely discussion. Just a reminder before he begins that Vivek has graciously agreed to take questions from the audience, so I encourage you to submit your questions in the Q&A function. So without any further ado, Vivek, over to you and welcome.
Thank you very much, Catherine, for that wonderful introduction. I'm truly honored to be here this evening, and I'm most grateful to the Society for inviting me, specifically to you, Catherine, to Mark Agrast, to Wes Rist, and to the organizing committee for this Practitioners Forum, and also to Case Western Reserve School of Law, our virtual hosts this evening. So my topic tonight asks the question, digital technologies and human rights, friends or foes? As a good law school professor, I'm going to give you the short answer, which is I think that they're really neither, that the better way to think of them is as frenemies, to use a popular term. So I'm going to explore that theme this evening. Now, just a couple of definitional notes before I launch in, which is to keep things manageable. By digital tech, I'm really going to talk about digital communications technologies, the things that we think make up the internet. The devices, the services, and the kinds of information that we share online. I had to do that because tech is everywhere in our society, right? There's digital technology in our dishwashers, in our cars, in airplanes. So that's one way of keeping it focused. Second is with regard to what are human rights? And I think it's easy for audiences in the United States, especially, to think about civil and political rights as the content of human rights, but there's also an economic, social, and cultural aspect to them in the international system. So just a brief roadmap. I'm going to begin by describing, what was understood to be the promise of technology for human rights, and show that in some ways the promise of technology has been achieved before turning to a bit of a darker side, the exploration of how technology has adversely impacted human rights, the foe, if you will. And then interrogating how it is that we got to this particular point before asking how the frenemy relationship can become a true friend relationship instead. So let's launch right in. So let's talk about the promise, right? Now, if we think back about almost 30 years now to the early 1990s, there was tremendous optimism about what what was then known as the information superhighway would achieve. So John Perry Barlow, a former lyricist for the Grateful Dead and a founder of the Electronic Frontier Foundation, penned something in 1994 called The Declaration of Independence of Cyberspace, which conceived of the internet as a different realm, one that was free of government sovereignty, of regulation. It's a very libertarian notion, but one where there's unrestricted freedom, the free movement of information, of ideas. And it was assumed that this exchange of information across borders, uncontrolled, would lead to positive things. And that was a reasonable assumption to make in the era, because this is right after the end of the Cold War, the fall of the East Bloc. And there's a lot of scholarship that posited that the reason that the Soviet Union collapsed is not just the economic contradictions of communism, but the role that communications media played in exposing the contradictions of communism, right? So we had the samizdat press in the Soviet Union, amplified by technologies like the fax machine, which allowed for the more widespread dissemination of information. Shortwave radio from Western Europe, all of which is seen as playing a part in what Francis Fukuyama famously or infamously called the end of history, right? This idea popular in the in the 90s, the first decade of this century, that in the great ideological struggle of the 20th century, democracy and capitalism had won, right? And that this was a world of increasing protections of human rights, and everything else was just basically details. And the technologies of communication that were being developed at that age were seen as, almost inevitably servicing the aims of the end of history. Right? And it was also assumed that even if things went wrong, right, in places in the world where atrocities or other gross human rights violations occurred, that technology would play a helpful role in documenting those abuses and in creating evidence for future accountability, right, in places like Bosnia and Darfur, among others, right? So this is sort of the assumption that we had, 20 to 30 years ago of where technology would lead us. Now, we live in the age of what's called the techlash right now, where there's a great deal of skepticism of technology, and we're exploring the ills that it causes, and that's healthy and appropriate. But I think it's important to remember that these technologies did achieve their promise in a substantial degree, right? So if we think back to Tom Friedman's book from the early 2000s, The World is Flat, a lot of what he argued in the book has come to pass, right? We do have global supply chains with just-in-time delivery across continents, facilitated by communication. We have the globalization of services, right? It is possible to outsource your taxes or learn the violin from someone in Jakarta or Bangalore or Brasilia. This has happened, right? We are having this conference virtually over Zoom, right? And we've seen a great globalization of culture, right? We've seen K-pop go mainstream in large parts of the world, all facilitated by the internet, right? The trends of virality in pop culture, right? And basically zero marginal cost communications. I can talk to my nonagenarian uncle in rural India over WhatsApp, and it costs practically nothing, right? So this is tremendous. It's transformed our lives, and I think if we think about the economic, social, and cultural side of the ledger, there's a lot that's very positive. There's been a lot of growth, a lot of human connection, a lot of material improvement in the quality and standard of living for a lot of people, right? That's all positive. And even on the political side, it was only a decade ago that we were celebrating the Twitter revolutions in places like Iran, Tunisia, to a certain extent in Ukraine as well, where it was seen that these new communications technologies, which could not be directly controlled by authoritarian governments in those countries, were basically allowing for the spread of truth, of true information rather than government propaganda, creating channels for people to organize, for opposition movements to catalyze, and for protests to movements to literally topple governments, as we saw happen in Egypt and Tunisia, amongst other places, right? And, one of the great tragedies of the last decade is, of course, the civil war in Syria, which rages on to some extent to this day. But internet technology has played an important role in documenting the horrors of that war, right? And creating the records that we're going to need for future accountability to take place. So it's important not to lose sight of that when we do explore what's gone wrong, right? And the faux aspect in this question of digital technology, friends or foes, right? And I think the last 5 or 6 years has really been, we've been focusing on some of the negative effects, right? Rightly so, because there are quite a few. And I think things really started to get a bit darker and more complex when we start to realize just how easy it is to shut this thing off, right? So, in the early 2000s, China began to build its golden shield, popularly known as the Great Firewall of China, right? An architecture by which the Chinese government could very finely censor what information was getting into the country, right? Either by blocking particular websites, blocking services, or even filtering certain kinds of words, right, on Chinese social media, for example. Now, these capabilities that were once only in the hands of China, as technology has become more powerful and cheaper, have diffused widely, right, to the point that a country like Uganda or even Chad has the ability to filter the internet in quite a sophisticated way, right? So that's a surgical instrument that one could use to shape what travels through these conduits. Of course, you could also just turn the whole thing off. And this was a tactic that pioneered really by Mubarak in the dying days of his regime in Egypt, right? Of just shutting down the internet, of shutting down cell phone service. And this is a graph of internet shutdowns around the world in 2018. And, there are several hundred, or about 200 around the world, 200 times where governments just said, we'll just turn the whole thing off as a way of preventing those information flows for a variety of reasons. So we have, contrary to what John Perry Barlow thought, it is possible for governments to act against these flows of information because the internet is not in the sky. It is physical architecture that is on the territory of nations or runs under the sea on cables, right? So there are places where governments can exert physical control over what happens online. But we've also built a vast edifice of digital surveillance, right? We'd call this the digital panopticon. And it has a number of different characteristics. There is mass governmental surveillance occurring online of what we do on the internet. And of course, the Snowden revelations expose this with regard to the NSA's PRISM program, but there are plenty of other programs like that around the world. And even post-PRISM, some of the abuses have been curtailed with regard to governments spying on their own citizens and democracies, perhaps, but there are plenty of authorities by which to do that to foreigners, right? So there's this vast array of online surveillance, but increasingly offline as well, right? We see the development of technologies like facial recognition, which are being deployed not only by China, throughout the country to surveil its population, but increasingly in advanced liberal democracies in a wide range of contexts, right? And this is, again, a form of surveillance that allows for your continuous tracking of your movements in public spaces, right? Technology facilitates this. We have the power to do these kinds of things now. But there's also an edifice of private surveillance, right? And I think Shoshana Zuboff at the Harvard Business School, who coined the phrase of surveillance capitalism, has done a great job of exploring this, right? And by surveillance capitalism, she means the business model of large internet platforms like Facebook, Twitter, YouTube, Google more generally, which collect vast amounts of data about their users to provide them with services that are nominally free, but are really paid for by targeting ads. And the commercial incentives of these companies are to maximize engagement with their platform so that more ads can be served. And that sounds fine if one is hawking toothpaste or sneakers. But as we've seen in the last 4 to 5 years, these technologies can be used to do great harm to human rights, right? Everyone's familiar with what happened in 2016 in the United States with the election, of how these micro-targeting tools were used to spread misinformation and disinformation during the election, not just by Cambridge Analytica, but of course by state-level actors as well. There's a lot of discussion, quite appropriately, about how these algorithms that make us want to engage with content lead us down filter bubbles, which can lead to extremism, right? Being recruited, terrorist recruitment, getting involved in militias, this sort of thing. And I mean, we've now seen several cases where these technologies have literally been used to assist in the perpetration of genocide, as in Myanmar, with regard to some of Facebook's products, right? So, and I haven't even talked about the risks of AI or the disruption that technology is causing in the labor market. It's only a 20-minute talk, so you'll pardon me for going quickly. But the point is that we found ourselves, quite far from the early optimism, right? It's a much more complex and dark picture, right? Hence the frenemies. And I think the question is why, right? Why have we ended up here? And, to go a little bit deep on this, the phrase popularized by Isaiah Berlin, which is originally of Immanuel Kant, right? That nothing straight was ever made of the crooked timber of humanity, I think applies with great force to thinking about our current predicament around technology and human rights. We assumed for a long time that technology by its nature, for some magical reason, would service democracy and human rights and these kinds of things that we like to believe in, right? That they were by their nature going to assist that, when in fact, we should know from historical experience that human beings, imperfect as they are, will use technologies to achieve whatever ends it is that they want to achieve, right? And I think a great example of this kind of flawed reasoning, right, is Alfred Nobel's view of dynamite, right? Nobel, when he invented dynamite in the mid-19th century, thought he was doing a great service to humanity by creating a destructive force so terrible as to make war unthinkable. Of course, that didn't happen, right? And his view of what his technology would do turned out to be too optimistic because, of course, people applied the technology for their own purposes to achieve their own aims, right? So the crooked timber of humanity is one part of it, but there's also the Silicon Valley adage of moving fast and breaking things. And by this, I mean, really relentless innovation, which in many ways is a positive thing, right? Innovation has brought many benefits to our lives. But at the same time, the rush to innovate without really thinking about the effects of technology has caused a lot of unforeseen consequences, right? The dark side of the technology, I think, can be attributed to this ethos of trying to put the product out there, thinking about how to commercialize it later, and then only in sort of as a third order priority, thinking about its impacts on society and on human rights. So that's another piece of it. But another really difficult problem is that many of the difficulties we face with technologies with regard to their impacts on human rights are dual use problems, right? Summed up in the adage that is loved by Second Amendment to defend aficionados of guns don't kill people, but people do, right? The idea that it's not the technology itself, it's the human use that makes the thing good or bad, socially desirable or not, right? And I think a great illustration of this is the debate that we keep having around encrypted communications. So from one perspective, encrypted communications, that's the key on the left side of the display, allow us to communicate privately without being listened in on by by governments, by our neighbors, by anyone else, right? So there's an element of privacy protection. Of course, that tool is susceptible to misuse, right? By terrorist groups, by child pornographers, by others who are trying to hide their tracks. And there's a legitimate role for the state to play as a defender of human rights in investigating those kinds of crimes and those threats to life, liberty, and personal security. So we have periodic calls to develop master keys in encryption. That would be the key on the right. To open up these locks. But then we are stuck in with the problem of how do we trust the holder of these keys not to abuse those inventions, right? And I think a lot of the dilemmas we face when it comes to technology with regard to human rights are these kinds of dual use dilemmas, right? It's true of the question of internet filtering, right? The same filters that can block child pornography or be used to make sure that bandwidth is being used in a fair way can also be used to censor, right? So a lot of it comes down to how do people use their autonomy and how to use the technology for positive as opposed to negative social ends, right? And that this is all happening, I think, in a changed context too, right? So if the 1990s were the end of history, we're now in the era of democratic democratic retreat of the human rights recession, right? And I think here it's important to note that the disruptions caused by technology in the economy, the growing inequality fueled by tech, has some part to play, I think, in the corrosion of democratic of norms and this sort of crisis of democracy that we're seeing in a lot of places. Okay, so if this is where we've been and where we are, the question then arises of how do we take these technologies and enlist them in the service of advancing human rights? Now, the first thing I want to say is that one of the great unsung developments of the last decades, I think, has been the rise of the business and human rights movement. So in 2011, John Ruggie, as special representative to the UN Secretary General on Business and Human Rights, released the guiding principles on business and human rights, which recognize the legal duty of states under international law to protect human rights, but a corresponding responsibility on the part of business enterprises to respect human rights. And respect is defined in the guiding principles as avoiding causing or contributing to adverse human rights impact. And the main way a business enterprise does this is by conducting due diligence, right? To basically think before one acts. So not to move fast and break things, but to be deliberate in developing a product or a service and launching it. Now, I don't think it's widely known or widely understood just how transformative this has been in big tech. Large technology companies now routinely evaluate new technologies or new products and services that are going to be deployed in difficult markets for the human rights impact. And it has made a difference. One can argue that it's perhaps too little too late because these platforms fundamentally have features in them that cause adverse human rights impacts. But this is an important change. I think it's a particularly important change with regard to artificial intelligence, which I see as the first transformative technology where we're thinking deeply about human rights impacts as the technology is being developed. Now, the problem with this is that, of course, the guiding principles are not binding in a legal sense. There's an aspect of voluntarism in implementing them. And we have companies that are not going to do it and some that are just bad actors, right? So this is not enough, right? A second important trend that is occurring as well is a growing recognition that the design of technologies has a lot to do with their human rights impacts. So this is a book by Woodrow Hartzog at Northeastern, who makes the argument that when we think about privacy in particular, architectural features of technologies really determine the privacy impacts of these technologies. And if we want to advance privacy, we should think about design rather than regulation, or in addition to regulation. And we can do this across lots of different technologies, right? Where small design tweaks can have significant human rights implications, positive or negative. A great example of this is WhatsApp, which was used to spread a lot of misinformation in India because you could forward a WhatsApp message to 256 people. They reduced that to 5 people, and the problem has reduced to some extent, right? That's an example of a design fix that can help smooth some of the rough edges of technology. So that's certainly part of it. But ultimately, again, if we think about the protect, respect, remedy framework laid out by Ruggie, or just, basic principles of public international law, the duty is on the state to protect human rights against all forms of violation, whether by state or non-state actors. So we do need the state to step in and regulate appropriately. And I think that is true for all of the different kinds of human rights problems that technology is causing, from interferences with privacy to the effects on our information ecology to growing inequality and sort of the fears of AI-fueled discrimination. So I think that's where we need to go. I think it's a good development that a lot of democracies, pre-COVID and now, even after COVID, are having these deep conversations about what the future of tech regulation should look like. So I'm an optimist at heart, and I wanted to close on that positive note, but I do need to darken the picture one bit, which I think the real big open question is around China. And what's happened, of course, is that China has become a global tech superpower. and is really the global leader in certain technologies, including facial recognition. And China has developed these powerful technologies in the service of an authoritarian political model that does not really believe in human rights. And as we saw with the Great Firewall, developed 15 years ago, which has been exported around the world, we are seeing China export this sort of package of technologies that are used to repress, use to close public space to other states. So I really think that the future is going to depend not just on what China does, but what on sort of states, especially in the global South, which of the two models they view as more attractive, right? The existing model of universal human rights, right, which has been developing, and the idea that technology should service human rights, or this sort of growing model that we see China being the leading proponent of technology acting really as a foe of human rights. So I'll leave it there and love to open it up for your questions.
Vivek, thank you so much for those thoughtful remarks. I appreciate the optimism and I appreciate the caution at the same time. We have a question that's come in. It's a big one. And it's the questioner says, can there be a, quote, normalization of the potential friendship if we're in a world where 2 to 3 tech giants hold all of the power and face no international accountability? And how does a globalized world achieve accountability of massive social media companies on which they depend for information dissemination?
That is a really good question, to which I don't have an easy answer. One of the things I've been doing in my scholarship is thinking of, can we find historical analogies for the situation in which we find ourselves in, right? And we have seen transnational corporations in other eras exercising enormous power, but of a different sort, right? It was not as intimately interwoven into the fabric of our societies, right? So I think that accountability question is really difficult. And I think the way that I like to think about it, and people inside the companies are starting to think about it this way too, is really sort of tying themselves to the mast of human rights. And we see developments like the Facebook Accountability Board, Oversight Board, for example, right? And its rules being established against international human rights principles, right? So using Article 19, for example, of the ICCPR as a lodestar for determining what Facebook's policy should be with regard to content, right? There's a separate conversation about competition policy that I could also speak about, but wearing my human rights hat, I do think that the human rights system and its structures and traditions actually do offer one pathway towards accountability for these companies.
Thank you, Vivek. And that actually brings the keynote session to a close. I wanted to take the opportunity to just thank you again for the thoughtful remarks, for giving us a lot to chew on, and just being here with us. So thank you so much.
My pleasure.
And with that, I think we are moving to our panel. And that discussion is on global issues related to arbitrating data breaches and privacy rights. The panel will be moderated by Brian Ray, a professor at Cleveland Marshall College of Law. Brian has extensive experience in information governance, cybersecurity, and data privacy, and co-founded and directs the Center for Cybersecurity and Privacy Protection. In 2016, Ohio Attorney General Mike DeWine appointed him to the Cyber Ohio Advisory Board. He co-chairs the Northeast Ohio Cyber Consortium's Workforce Development Committee and is a member of the Sedona Conference's Data Security and Privacy Liability Working Group. He was a Fulbright Scholar in South Africa and has published extensively on comparative constitutional law and social rights. Brian, welcome, and we look forward to the discussion with you and the panelists.
Thank you. It's a pleasure to be here. Okay, so thanks everyone for joining us this evening. We've got a really wonderful and experienced group to discuss these really interesting issues. There's a lot of ground that we could cover, and so we had to pick and choose among topics, but we're going to try to touch on both some of the issues or the core issues related to consumer arbitration of data privacy and data breach issues, as well as then turning to business issues, which, as you can imagine, are quite different. I'm going to ask and apologize for asking the distinguished panelists to give their own very, very brief biographies to tell us a little bit of who they are and how they fit in this space, and then invite our attendees to please look on the website for more details about their rich experience. And so first up, I'm going to ask Chrissy. And Chrissy, I think you've got your video off, but if we could, and actually while you're getting on, why don't I ask Steve to start first? And Steve, why don't you go ahead and introduce yourself?
Sure, thanks, Brian. My name is Steve Stransky. I'm a partner at the law firm of Thompson Hine. I'm also the vice chair of its data privacy and cybersecurity practice group. My practice is generally broken up into 4 areas. First and foremost is data privacy compliance, where I help multinational companies comply with a broad range of data protection laws, regulations, statutes, court orders. Another part of my practice focuses on IT contracting or third-party contracting in general, which is obviously a key part of data protection. Part of my practice focuses in the M&A space, in which I have clients making acquisitions or purchasing other businesses. I will help them look at that target company's cybersecurity compliance portfolio so they can identify the risks along with that purchase or that transaction. And then the fourth part of my practice, unfortunately, focuses on data breach response, in which I assist clients comply with their own obligations and making notifications following some type of security incident or data breach. I've been with the firm for about 3 years now. Prior to that, I spent 10 years in the federal government, working at the State Department, the U.S. Department of Homeland Security, and worked for a little bit at the Legal Advisor's Office at the National Security Council. And so I just want to conclude by saying thank you, Brian, and thank you, ASIL, for having us here, and hope it's a good conference and a good presentation.
Excellent. Thanks, Steve. And Chrissy, if you don't mind going next.
Hi, yeah, sorry, I was trying to unmute. So I'm Chrissy Soul. I work at Square. And for those of you who don't know, Square is divided into 2 business units. The seller side of the house, which is what you see as our payment processing products. And then the other side of the house is Cash App. Cash App is a consumer financial platform. And I've been with Cash App for 5 years, growing into the role of lead legal counsel for Cash App. And on my team is our regulatory counsel, our product counsel, our commercial counsel, and our licensing managers for the various products that require licensing on Cash App. And through our regulatory and product counseling efforts, we review all privacy issues, including drafting our privacy policy, both in the UK, where Cash App launched in 2018, and here in the US, where Cash App has been live since 2013. And I want to echo my colleagues' sentiments. Thank you, ASIL, for having us on this panel.
Thanks, Chrissy. And Kathleen, welcome.
Hi.
And if you don't mind, give a brief intro.
I'd be happy to. I'm Kathleen Paisley. I'm an international arbitration dispute resolution professional. I'm based in Europe, well, between Europe and New York. And I've been doing international arbitration my entire practice. For better, for worse, I also have done a fair amount of data protection work. My practice has always been a combination of technology and arbitration. And when you're based in Brussels, that means you do a lot of data protection. So I combine those skill sets. And as a result, when the GDPR came into force 2 years ago, I became very involved with the group of people who were involved with educating the arbitration community about cybersecurity, data protection. So I've been on three major task forces about the application of the data protection rules in arbitration and cybersecurity in arbitration. But also there's also the question of disputes that arise out of violations, which is what we're going to talk about today. So it is an honor to be here. I'm delighted. Thanks so much to ASIL and to all of you. I think it's going to be a great discussion.
Yes, definitely. And Kathleen gets double thanks for joining us on Brussels time. at this late hour, but she's got such rich experience. We really wanted to have her on. So thanks, everyone. Let's jump into then our discussion. And we decided we'd start with just a very, very lightly sketched hypothetical. We've got a multinational company with operations in Europe and the United States, considering whether and how to include and structure arbitration provisions in its various contracts, both consumer and business to business. And we'll start with the consumer issues. And Kathleen, if you could share your experience in working through how GDPR applies in this context where you've got consumer rights at issue.
Right. So the GDPR obviously grants data subjects significant rights, and those rights can be enforced in two ways. They can be enforced either through going to your local DPO, and that right is very difficult to waive. In addition to that, the GDPR gives an individual data subject a specific right to claim damages. And it also puts in place pretty much, I don't want to say for the first time, but certainly for the first time in such a concrete way, a set of principles that allow consumers to bring class action suits and allow them to appoint nonprofits to basically handle those data protection claims. Each claim for damages would be relatively small, but because the way the rules work, the anticipation was when the GDPR came into force that we would see waves of class actions for data protection breaches brought by consumers. Some, I shouldn't say many, but some of the major class action firms set up offices in Europe. And it took years before we saw a lot. But in the last 2 months, there've been a potentially $10 billion claim brought against Oracle and Salesforce in the Netherlands. A similar size, maybe a bit smaller, against Marriott in England. So we're starting to see that, which has obviously brought companies that have the potential risk of a large data protection class action, or just a lot of claims that would have expenses, to start thinking about whether arbitration is an alternative. And as in the United States, that raises all the questions about whether arbitration clauses are enforceable against consumers, enforceable against employees, enforceable against the kind of individual data subjects that would be bringing those claims. And it's difficult in Europe, I would say.
Yeah, and we'll go into those in a little more detail, but it's interesting to hear how a distinctively European approach to privacy has brought into play what many would say is a distinctively American approach to litigation and
Yes.
And individual consumer protection. So yeah, it's a very interesting set of circumstances. And so, Steve, tell us a bit about what this company might have to think about in the U.S., where the context is quite different. Or maybe not so different, right?
Yeah, absolutely. So, as you know, in the United States, we do not have one comprehensive data protection law like you have in the GDPR. But that doesn't mean we don't have data privacy laws. Quite the contrary. We have quite a significant amount of data privacy, data security laws in the United States at both the federal level and the state level. But the outlier is that these data protection laws don't generally grant individual rights. And I'll give you a few examples here. In the United States, we have a federal law called the Health Insurance Portability and Accountability Act. It highly regulates the type of ways organizations can collect, retain, and dispose of patient records or information on generally in the healthcare space. You have a federal law called Gramm-Leach-Bliley, the GLBA, which regulates how financial institutions, primarily banks, and regulate or use, collect, and share non-public information, or NPI, on their own customers and clients. You have a law called FERPA, the Family Education Rights Privacy Act, which regulates how universities and schools can use personal information on students and student records. We have the Short Communication Act, which generally regulates the content of communications. You also have CAN-SPAM, again, another federal law that regulates the use of marketing, whether in B2B or the business-to-consumer context. The primary underlying issue in all of these federal laws. And let me go back and also say the FTC Act, the Federal Consumer Protection Law, which generally has been interpreted to require organizations to maintain certain security protocols when they collect consumer data and to make sure they don't misrepresent their data processing activities. These laws generally do not create private rights of action. So if the organization has breached a right underneath the law, generally the consumer's recourse is to file a complaint with the FTC, with the Secretary of Health and Human Services, or a regulatory body at the federal level who could choose to investigate the incident. And there's some outliers there, including something called the CCPA, which I'll get back to in a second. But this type of regime at the federal level in the United States is actually mirrored at the state level as well. In the United States, all 50 states have their own data privacy laws. All 50 states have laws that regulate, for example, how organizations have to notify consumers and individuals of a data breach. Many states have their own specific type of requirements on how organizations retain or the type of security measures they have to employ to protect consumer information. Some states have laws that regulate how organizations can dispose of personal data. Again, when there's violations of these laws, though, they generally do not create a private right of action. They require that the consumer or the individual to file complaints with regulatory bodies, potentially law enforcement, who have the discretion on whether or not to investigate these type of incidents based on priorities. And then again, there's some outliers at the federal level. You have the Telephone Consumer Protection Act, CCPA, which does regulate unsolicited phone calls and text messages, whether used for marketing or other purposes. And violations of this law does create a private right of action, quite a strict liability, so to speak. And arbitration is something that we've seen organizations use as part of the remediation effort in the event of a breach of a contract that involves or the CCPA rights. And then we'll come back to this as well, but at the state level, we also have relatively new, the California Consumer Privacy California Consumer Privacy Act of 2018, which likely will be amended in about 5 days now, when the California residents enact the California Protection Rights Act, the CPRA, which will significantly amend the TCPA and make it more aligned to the GDPR, in which you have the right to access, erasure, rectification, not sell rights, which are kind of analogous to a cessation of processing rights under the GDPR. And in the CCPA, again, it's one of the more comprehensive state-level consumer protection laws we have in the United States, and it does provide for a private right of action in very narrow circumstances regarding data breaches. So I'll summarize by saying when in the United States, it is definitely quite a different legal framework than in the EU, and businesses have to be aware not only of the sector they're in, but the federal and state law, the type of consumers they're dealing with, and the type of data to understand what their legal liabilities are for breaches of these many different data protection laws we have here in the States.
So
yeah. Go ahead, Kathleen. Yeah.
I was just going to say, not to crosstalk, but I wouldn't want anyone to get the impression that in Europe you only have to worry about the GDPR, because that would be much too simple.
Right.
Because the GDPR replaced the General Data Protection Directive, the Data Protection Directive, and the Data Protection Directive, all the member states already had data protection laws. So the GDPR did not require, so the regulation applies across Europe, right? So it essentially creates a floor, but it allows deviation, and all the member states still have their data protection laws, which vary in important ways. So if you're in Europe, make sure you check your local data protection law. And that'll come into play in this hypothetical as well, because all these issues as to whether you could arbitrate, whether you couldn't, all that is regulated at a national level. So you'd have to look in each country as to what was arbitral, what wasn't arbitral, what was, so it's not as the GDPR is in fact a federal regulation of sorts, but it still doesn't preempt the states. There's quite a broad room for discretion, but you at least get what's in the GDPR. So just a complicated.
Yeah, no, that's a perfect point. And as we discussed when we planned, we're definitely going to talk within each other, we created a somewhat overly simplified hypothetical to try to get at some of these core issues. And I forgot to invite our attendees at the top to please submit questions directly throughout. We will save some time at the end, but we'd like to get your questions and we'll do our best to integrate them into the conversation. So please feel free to submit them along the way. If we don't get to them now, we'll definitely turn to them by the end. And so returning then to our somewhat simplified hypothetical that uses GDPR as a kind of meta stand-in for at least the core issues you'd have to think about in this consumer context. Chrissy, what would this company then have to think about given this backdrop we've laid out?
Yeah, I'd love to talk about how to think about this both in the UK and in the States. Specifically, in what we were talking about was the B2C context, right? The business to consumer context.
That's right.
So to Kathleen's point, it's definitely not possible to compel arbitration in the United Kingdom. And the reason for that is UK courts deem non-negotiated arbitration clauses in a B2C contract. So these user agreements, these click-through agreements, they deem arbitration clauses in those to be unenforceable in most instances, unless the company can show that the consumer made an informed decision to agree specifically to the arbitration clause. And you could see the the friction that would be involved in making sure that there is a mutually agreed upon arbitration clause in these click-through agreements. What would a company do? Would they allow for a plain text so that you can negotiate the terms with your customer? How would you actually productize a mutually negotiated arbitration clause? It's almost impossible, which is why you see it not being possible to compel arbitration in these circumstances. But what is possible in your end user agreements is to have arbitration as an option. And that's something that we do at Square. On our general terms of service, we include arbitration as an option for all disputes, including those disputes that would arise under a GDPR context, right? And then flipping to the US. So, looking at the US, right now, the one regime we have to look to is California's with the CCPA. And I believe over time, more states are going to come down with their version of the CCPA, and there's talk of a national Privacy Act as well. But let's just talk about what we know is in effect today, right? So with the CCPA, and it allows for a private right of action. So there's actually a conflicting view of whether a consumer can be compelled to arbitrate their CCPA claim, right? Under the CCPA, it details that any provision of a contract or agreement of any kind that waives a consumer's right, including a remedy or a means of enforcement, would not be enforceable. That would be void and unenforceable. So the CCPA might take the position that compelling arbitration may be limiting a consumer's right. My computer just went to sleep mode. I'm sorry. Then on the other side of that, I said we have conflicting views. The other view is the Supreme Court's view. And the Supreme Court has repeatedly turned back California's attempt to limit arbitration. The Supreme Court wants to bolster arbitration and have people use that as a means to settle disputes. So it's yet to be seen which one is going to win out here, and experts do believe that this will be litigated soon. So what do companies do? If you have this conflicting theories, it hasn't been litigated yet, but you as a company might want to preserve your rights for arbitration. And so what you want to do is in your agreements, make sure that the arbitration clause that you've drafted would be upheld as enforceable, because in the case that you can arbitrate CCPA claims, you want to be able to have that arbitration clause be enforceable. And so you look to two types of, courts generally, when they're reviewing arbitration clauses, they want to see if it's conscionable. And they look at two types of conscionability, and the court must find both of these types of conscionability to not be there in order to not enforce the arbitration clause. So that's a lot of negatives. Let me put this in the positive. So there's two types of conscionability: procedural and substantive. As long as you as a company have one, either procedural or substantive conscionability, your arbitration clause will be upheld. So let's break that down. Procedural conscionability means, is the process used to agree to the arbitration clause fair? And there's a number of ways to test fairness of an arbitration clause. One of them has been, if at the top of your terms and conditions with your consumer, do you have bold and all cap text saying, please review these terms and conditions. They include an arbitration clause, directing the customer where it is and what to be looking for. That's going to bolster that you have procedural conscionability. The second one is allowing a customer to opt out of arbitration, right? This goes back to what the UK was saying, where how can you actually tell that it's been negotiable? So this is the US's way of showing that there's some negotiability where a consumer can actually opt out of the arbitration clause and then, take their dispute to the courts. And then you look at substantive conscionability. Are the terms of arbitration fair? Do you allow for an appellate review? Are the costs of arbitration fair? And so long as a court finds that you have either procedural or substantive conscionability, they will uphold your arbitration clause. And then you'd be in a very good stance for once whether you can arbitrate a CCPA claim. If it's yes, you can, then you know that you could rely on your arbitration clause and it will be upheld as enforceable. So that's just a little bit of the practical application of thinking through how to arbitrate privacy issues under either GDPR or the CCPA.
So thanks for that, Chrissy. And so we've got uncertainties on both sides of the Atlantic. And Kathleen, if I could turn to you and just want to explore a little bit more what it would mean as a practical matter that under GDPR as sort of the baseline, a consumer could opt out at any time. And if you could tell us a little more about what are the uncertainties there that a company would need to think about?
Yeah, I mean, it is extremely difficult. I mean, this, again, very broad brush statement about things that are nuanced. But, Europe has a very strong pro-arbitration stance, similar to that in the United States. In fact, in some countries, even stronger than the United States pro-arbitration approach. But that does not apply in the consumer and employee context. So there's a view generally that it is inherently unfair to force a consumer or an employee into arbitration, and it's therefore really not done. So there aren't even that many test cases because and also because arbitration is not because the courts are a different animal. They're not as expensive. So there just is less of a need for arbitration in small disputes like a consumer disputes. There aren't jury awards, so there just isn't the same kind of incentive for consumer arbitration or for employee arbitration. So there isn't a huge amount of law on it as a general matter. But if I could grossly oversimplify, there is there would be a strong anti-enforcement bias against a consumer arbitration clause to address data breach disputes, for example. And so I think there would be uncertainty if you put a data arbitration clause and relied upon that for a data breach dispute. Now, I think if after the breach has arisen and so there's been a breach and consumers, for example, are, your group, your group of data subjects. I won't call them consumers because they're really any data subject. You know what your group is. And then if you go to that group and you say, would you now like to agree to arbitrate instead of going to the courts? And they say yes, and they sign on the dotted line in a form that is a fair agreement, then I do think that would be enforceable in order to avoid a court claim. Now, the question would be, if that arbitrator decided against the data subject and said it wasn't a problem, would that be binding on a DPO, on a data protection authority? And I think that's a different subject because the data protection authorities are very jealous of their jurisdiction. But, really what you're concerned about in that context, I think Chrissy will correct me if I'm wrong. I think mainly what you're concerned about is that the consumer is not able to go to court. And I think if they've signed on after the breach arose, so after they knew what they were agreeing to, if the data subject signed on, I think it would be enforceable in that context. But if it's a pre-dispute clause, I think it would be difficult in the data protection context.
Yeah. So although there are some similarities, it sounds like the emphasis or the default starting point in each jurisdiction would be very, very different. Whereas in the United States, we've got an interesting clash coming between CCPA and federal preemption of state law in the arbitration context. Whereas in Europe, both by practice and convention, and now with the added strength of consumer rights under GDPR, it sounds like it would be difficult to get a U.S. style arbitration opt-in or really arbitration with opt-out provision enforced. And Steve, what are your thoughts then? What are you telling clients about what they need to worry about or think about with the CCPA and including arbitration clauses in this context?
Sure, there's a couple things that come to mind. And the first is we've glossed over this a little bit, but the Federal Arbitration Act is the federal law that basically sets as public policy or encourages as a matter of public policy the ability for organizations to engage in arbitration as an alternative to judicial litigation. And because it's a federal law, it has been interpreted to preempt state laws. And I think Christy mentioned this before, it's already been interpreted to preempt other California laws that have tried to restrict arbitration. And we've seen it enforced in the data privacy context, primarily in the CCPA lawsuits in which there are private rights of action and courts upholding the ability for companies to arbitrate those violations as opposed to going through other types of remedies. What we try to be very cautious about, and I think Christy touched on this in a couple points, is crafting the right terms and conditions that you're putting in your contracts. And obviously they're going to be different for your consumer versus different, or they're going to be different in the consumer context and in the B2B context. And one of the things that Kathleen was mentioning was this is primarily driven by the data breach context. But we've also seen, obviously, a large emphasis on what I refer to as the data limitation rights, right on the CCPA, the GDPR, that organizations are restricted from using personal data in a way that's not compatible with their means and purposes of collecting it, the type of notice they've given to consumers. And so potentially you have an ability to bring a lawsuit or potentially a breach of contract claim if an organization is using data in a way that they're not authorized. But again, when you're drafting your contract, you want to make sure that the rights that are being arbitrated or sent to arbitration based on a breach of contract, that those rights are precisely described under the terms and conditions of the contract. And what I to give you an example is one of the CCPA lawsuits. It was I think it's an 11th Circuit case that came out just a few months ago that focused on a car dealership that entered into obviously a consumer transaction. Consumer purchases a car from the dealership, and in that contract did not mention anything regarding to follow-up communications from the car dealership. Within weeks, months of the purchase, the consumer then started getting text messages. And the issue was that there was an arbitration clause in the purchase agreement, but it didn't mention anything about the CCPA. It didn't mention anything about the about communication in general. It did have an arbitration clause, a standard one that was very broad. And the courts basically interpreted that the text messages coming from the car dealership were not in violation with the contract. They had nothing to do with the contract. The contract itself had to do with the purchase of a car. And so what's really important, anytime you're engaging in a consumer transaction that obviously involves some type of contract, that you're wording, you're putting in terms and conditions that clearly articulate the scope of the contract and any type of ancillary activity that may occur. It's very, very common to include general terms now out of fear of CCPA litigation, out of fear of can-spam litigation and CCPA, including terms that say, by executing this contract, you're also consenting to us contacting you, right? Regardless of whether it's for marketing or warranty-related claims, whatever it is, you are consenting to it. And putting in very, very precise terms to ensure that even if there is a breach, you can invoke your arbitration clause because that breach is somehow related to the contract. So that is something that we are seeing contracts now in the consumer space include a lot of data privacy terms that weren't in there a few years ago to address these type of issues.
I mean, not to crosstalk, but I just wanted to make one point because I think it's interesting, which is that, you know, the huge claim against Oracle Salesforce is about a lack of cookie consent. So it's not about a data breach. It's about whether they had proper consent for their cookies. And it's potentially, I think they're estimating a $10 billion claim. And they're all tiny, but they add up.
Yeah. So that's interesting. And so, you know, one of the things I was going to say in response to Steve is, of course, that approach of just trying to cover everything with your consent clause is in part, you know, the way that consent works under U.S., both, you know, general tort law and then even under the CCPA, which is different from in Europe, right? Where consent, I don't think you could just draft an all-in consent clause and say, okay, I'm covered now, right?
Yeah.
Okay. So we had a question. Go ahead, Steve. Yeah.
I would, if I was in Europe, and luckily I don't have to deal with the GDPR. It's interesting you mentioned cookies. I had a question the other day about cookies within the e-privacy directive and the fact that you have, I think, 16 different variations among the member states on what is a cookie wall and what's acceptable. But I would make the argument that when we do draft our contracts, it is not, it's framed in a way that it's not consent or basically one consent to the contract consents to everything. You know, a lot of our contracts can be negotiated, and then the consent clauses that are built in are very specific to the provisions, have their own processes. But I understand your concern, Brian, and I would agree that if our contracts, even though they are one term that, you know, 65 pages of different consents, it's still one contract.
Very specific.
Get you in trouble.
Yeah, no, didn't mean to cast aspersions on your drafting, Steve, but go ahead, Kathleen.
What the EU has said about consent, I think, is cute. They say consent is a false good solution. So they really argue, they really strongly take the view that with respect to the GDPR, one relies upon consent at their peril. But that's a slightly, yeah. But that, we always these days try and focus on another means if we can, because it's very tricky in Europe to get consent. It's very difficult.
So we had one question, but I want to, since we're running a little late on time, I want to shift to the B2B context, and then this question relates to consumer. I'm going to circle back. I promise to get to it, but no later than the end. I'll make sure we do get it in. But let's move to B2B, and so in that context, thinking about our same multinational, though it's very different here. If that multinational is now going to think about its business-to-business contracts, what are the issues that it needs to think about? And we'll go to Kathleen again to give us a kind of overview here.
Well, you know, the GDPR is the main things to focus on in a transatlantic context is data transfer, probably, because what the GDPR does is effectively, we refer to it as soft enforcement. So the GDPR is a very broad scope. So it isn't because you're in the United States GDPR doesn't apply to you, as Chrissy and Stephen will be able to tell you, and you from your clients. The GDPR is a very broad scope. If you monitor someone in the EU purposefully, you're subject to the GDPR. It's very broad in and of itself. But then, in addition to that, if you want to transfer data between Europe and the United States, for example, you need to have a separate lawful basis for that. And in order to get that lawful basis, often what people rely upon are provisions that then require the person who is not otherwise subject to the GDPR, notwithstanding its broad scope, to agree to apply the GDPR in order to have access to that data. So that's one thing I think that is important to think about when you're a business doing transnational transactions with Europe. I mean, the other thing I think to keep in mind is that, the basic principle of the GDPR, I think that is hard for me, even after all these years as a North American, or even just someone who's involved in tech work, is that data processing is not lawful unless you have a lawful basis. You cannot process my personal data unless you have a lawful basis for doing that. It sounds crazy in a digital world in which everybody processes personal data all the time, but it's that separate mindset that it's prohibited unless allowed that is really difficult, I think, for people to get their minds around. And then those lawful bases, as I said, consent is usually tricky, almost very difficult to get from a consumer, almost impossible to get from an employee. If you rely upon consent for processing and the person withdraws it, you have to stop. You can't say, oh, well, then let me rely on this instead. You have, once they withdraw consent, you have a problem, a serious problem. So what?
Yeah, so this is actually really interesting. I don't mean to interject over you.
Please, it should be a discussion.
Yeah, please.
But when we were doing our data mapping for GDPR, we were definitely looking at lawful bases, right? Yeah. And to your point, consent is hard to get. So there are several types of lawful bases, and some are stronger than others. And some of the lawful bases that are stronger are processing the data for like fraud and risk purposes, processing data because it's necessary to provide you the service that you're requesting from us. And so the way to not provide consent from that is don't use the service, right? So if you want to use the service, a lawful basis for us to process your data is to provide you with that service. So that's B2C. But then let's move into B2B, right? So if also for me to provide you the service, I need to process your data, but I need to use a third party to also process your data. Think of it in terms of like an IDV scenario, right? So I need to run identity verification on you to provide you with my service so that I could be compliant with my like AML and BSA regs and those local regs in Europe that are synonymous to AML and BSA. Yeah. So to do that, I have to contract with a third party and then do what Kathleen was saying, data transfer, right? And so when I'm doing that data transfer, a contract is actually another legal basis to be processing your data. And so
provided, and this is the tricky part, provided the data subject is the one who is subject to the contract, right? So a contract with me as a business does not give you the right to process the data of my data subjects. It's only if I'm the data subject. So that's.
But don't you get there through the privacy notice, right? Because if you've agreed to our privacy notice, and in our privacy notice, we're telling you that to provide you with our service, we need to process your data through a third party. Doesn't that get you through?
If I'm the individual data subject, yes. If you're trying to do that through a company, so if you're saying to me, let's say, for example, you want to provide a service to my law firm, and in order to do that, data has to transfer, then as long as it's me who's subject to the contract, you're fine. If it's my employees that also come over to you, that contract provision doesn't apply. What does apply, which is what you were speaking to, is legitimate interests. And at the end of the day, what most people rely upon at the end of the day is legitimate interest for data processing, but legitimate interest doesn't allow transfer. So it's very tricky. And that's why, back to, I'm looking at Captain Amafir's name, and in arbitration, what we deal with a lot is this question of, you have a need to process a lot of data in an arbitration, not all of which, it's of data subjects that are unrelated to the actual people who brought the case. It's an employee, it's a contractor, and you've got all this personal data you need to process. What is the best basis for processing all that data? And it's a very interesting question, but it is tricky. And the contract thing, I think, is, I was just looking at this last night, and it's tricky. But anyway, it's interesting, yeah. But consent is difficult, very difficult. Mm-hmm.
And I mean, that same set of issues comes up, of course, in litigation, especially with discovery disputes here in the U.S. And our federal judges are very sympathetic to European privacy law and usually just yield to it, right, Steve?
Yeah, but that's what I've seen in my practice. Boy, they just say, no problem. You don't
need it.
We don't want to see it. No, we're not gonna have a lawsuit for 10 years in Ireland over some data. No, not us.
I think what helps in that case is the guidance issued by previously the WP29 and then endorsed by the European Data Protection Board, which has essentially said it is in your legitimate interest to comply with foreign law, to comply with foreign litigation. So it's not, as you said, it's not that this is prohibited from exchanging data outside Europe for litigation purposes, arbitration purposes. But there's very strict rules on how you can do it, including minimization, including redaction, and then what we see in a lot of our contracts, including a lot of these flow down clauses to adverse counsel who is collecting personal data, and they're clearly not subject to the GDPR, but in order to actually access it, having them required to a lot of these data minimization procedures as well. And I think the courts have generally interpreted it to essentially, most of the case law that's come out since GDPR is we don't have a conflict of laws here between GDPR and U.S. discovery. They can be done. They just have to be done in a very methodical and strict way.
Yeah, that's it. I was going to say that. That's exactly right. You can, and there's very specific rules about how data can transfer for litigation. But the application of those rules means you get a more limited data set. That's all. It can't be duplicative. It has to be redacted where that's appropriate. You have to prove it's necessary. It has to be an occasional transfer. So an occasional means like it can be more than once, but not a lot. So it's got to be occasional. It's got to be necessary. It's got to be minimized. So there's a lot of rules that apply in the litigation context. And
if I can, I just want to jump in because Chrissy mentioned something in our pre-meeting about insurance, and I kind of want to circle back to that and hear her points on it as well, because we've been talking about the business-to-business context. Obviously, especially when you're using a third-party service provider, as described in Chrissy's example, when you're in the U.S., again, the obligation on the service provider is generally just to give you notice if there's been a data breach. If you notice that it can't give you access to or erase information, there's not a lot of liability that arises out of that. So the liability is dictated through these contracts. It is, as I mentioned previously, it's one of the most contentious parts of negotiating IT contracts is who is going to be responsible, who is going to be liable in the event of a data breach, especially when the data is retained by a third-party service provider. How do you mitigate that risk, including doing your own due diligence and the type of security controls that your service provider has in place? And then a very important issue, obviously, is going to be in the event of a breach and a breach contract, whether that will be subject to arbitration. But as part of that due diligence, using cyber insurance as a way to mitigate the risk. And I know if you want to jump in and talk about this.
Yeah, no, I definitely take this one. So, what we do is we have a template document that we attach to our contracts where we know that the party we're contracting with is going to be processing data, we're going to be transferring data to them, et cetera, and there's going to be a vulnerability for breach, right? So this attachment that we attached to the document. It's called a data protection addendum, a DPA, right? And so we have our template agreement that is what we go with out the gate, and then subject to negotiation with our third party. And there's a few provisions in it that are very telling about how we think about being made whole in the event of a data breach on the vendor side, right? So the first thing you do is what we look towards the master agreement for the dispute resolution and jurisdiction clause, right? So that's where we will either negotiate in an arbitration provision with our vendor, or it will be a jurisdiction and other dispute type of resolution in the master agreement. And then looking in, and that'll be what's guiding us when there is a dispute. But then you look to the DPA, and the DPA is going to talk about indemnification and insurance, right? So we will be specific about the indemnification obligation of the vendor if they are to blame for a data breach, right? So basically you want to make sure that there is a provision that keeps them on the hook in the event that they cause a data security breach. So that's the indemnification clause, so that any costs that you incur based on their data breach, you will get indemnified for. But a lot of times you don't know, unless you do a lot of diligence on your vendor, can they afford to pay you out? Like how deep is their market capitalization? And also, what is the degree of sensitivity of the data that you're providing them, and the quantity, right? Because if it's sensitive data and a lot of it, then you can see that these costs can go very high. And so we always talk to our business team to really understand the sensitivity of the data and the magnitude of the data we'll be sending over to our vendor, so that we can then understand the insurance clause, right? Because if you are unsure whether your vendor will be able to make you whole for those losses, then you request a cyber insurance policy, and you put in what you believe is the right number. Is it 2 million? Is it 5 million? Is it 25 million? What do you want that insurance policy to cover? And then again, the way to get there is sensitivity in the data that you're providing and how much data you're providing to your vendor. And then you hash that all out in the contract beforehand, and then if a data breach occurs, you're covered.
Yeah, and so when we think about arbitrating these issues, including an arbitration clause in the B2B context, there's not that same set of concerns, right? Is it pretty standard then, Kathleen, even in European B2B contracts, that you'd have an arbitration clause that would cover these kinds of situations and then deal with the risk side of it in terms of indemnity and insurance through these other clauses?
Well, I mean, usually in my experience, the data protection obligations, the data breach provisions, the cybersecurity requirements are, as Chrissy described, in the context of a bigger relationship, right? So you have a license agreement, or you have a whatever, and that will have, these days, invariably have data protection obligations. It will have security obligations. But in addition to that, as Steve rightly pointed out on our call, it will have a limitation of liability clause, and that will be probably both a cap and no lost profits, et cetera. So the question then becomes, what are you claiming for if the limitation of liability is enforceable? But that's an issue that is equally applicable to everything, right? And in a commercial context, what I think it's fair to say that between two businesses, if we want to allocate our data protection risk in a particular way, that would be enforceable, and that would be able to be undertaken through arbitration. If the contract is subject to arbitration, the arbitration clause would be enforceable in the same way it would be enforceable for any other provision of the contract. So I think it's a different dynamic. Now, yeah, go ahead.
I always laugh every time I see a contractual clause in the warranty or limited liability clause that says the liability cap has been negotiated because it properly represents the risk to both parties and they agree upon the same, when that contract's non-negotiable, right?
Right. This is non-negotiable, but we've negotiated it.
Right.
So I mean, I do think, and I mean, we are increasingly seeing cybersecurity and data or data breach or cybersecurity related issues being arbitrated and being the subject of commercial arbitration in the same way as other contractual issues and subject to the same sorts of contractual limitations, insurance requirements, et cetera. So I think it will be, and I think it will be an increasingly large part of the arbitration mediation pie because, as the larger these claims become, and when I started doing this 30 years ago, you sometimes would see big contracts that had courts clauses, particularly, in the tech area. You'd seen California cases, California parties where I was with Morrison and Forster, and sometimes we, if we wanted to, could negotiate a litigation clause for the California courts. That's almost impossible now. In these big contracts, they all contain arbitration clauses.
And I'll say that we've seen trends, right, in litigation and trends in arbitration, and obviously years ago, when if the organization was subject to a data breach, their first response may be to litigate, because we still have arguments that there's no harm, therefore the courts don't even have jurisdiction, or in the United States, there's no federal actual law here that would give them a viable claim, and you have plaintiffs relying on unjust enrichment and estoppel related claims, and you have businesses willing to litigate that. And obviously, what the trend is starting to be, let's just settle as quickly as possible. We have insurance, let's invoke it. We primarily, not because of maybe the cost of litigation is a factor, but obviously the business reputation is so important now, and we see this trend trade off a little bit between fighting litigation, going to settlement. It'll be interesting to see now where arbitration as a viable mechanism, now that that some of these claims are being a little more disputed, instead of going directly to settlement, where arbitration would play more of an important role here.
Yeah,
there's something that we're seeing in the United States that is actually using an arbitration clause against you when you're a company. We're seeing this with DoorDash and some of these other gig economy companies, where they want to be forcing arbitration. And what's happening is they'll say that they'll cover arbitration costs, and then the claims themselves are not very high in cost, but the arbitration itself might be higher in cost. And so what firms are doing are helping people bring mass arbitration. And then if you are forcing people in your agreement to waive class action, and then these really smart firms are bringing you a mass arbitration, what you at one point could have taken care of in a class action, which might have been lower costs, you're now getting pummeled with mass arbitration, the tune of like millions and millions of dollars above what you would have paid if you didn't have the class action waivers. So it's a way where now arbitration clauses seem to be having this double-edged sword, and it's coming back to really be costly for companies in this type of a mass arbitration situation.
And I would like to point out again that that's one of the differences between consumer context and non-consumer context, because those issues only arise in the consumer context. But in the B2B context, I mean, I think one thing one realizes about these, particularly data breach claims, is the potential for confidentiality of arbitration is important, because a lot of these companies don't want it to become public that they've been subject to a breach. I mean, that's becoming increasingly difficult in the world in which we live, but it's still a factor. And the other thing I would say is, I've been involved with, I mean, pretty much, 2 or 3 of the major international arbitration institutions right now are involved in looking at the use of arbitration, particularly for technology and life sciences, but especially for technology, including cybersecurity. And I think that, and what we're looking at, I'm co-chair of the AAA ICDRs, and what we're looking at is sort of what are the special things about these claims that make arbitration particularly helpful. And one of them is the ability to have people who really understand both the technology and the business, and that's not always straightforward in a litigation context. And there are others, but I mean, I think this whole notion of, you run a technology case differently, and you don't have as much disclosure. So there's some real benefits to arbitration, particularly for technology cases, and particularly for cybersecurity and data breach cases. So.
Yeah, that is a really interesting issue, because one of the things that I encounter in some of the groups I'm with is, judicial education in cybersecurity is, it's something that, and other technical issues, but cybersecurity in particular, when you think about a breach issue, I actually helped draft Ohio's Data Protection Act, which provides an affirmative defense if you're following, among other possibilities, the NIST framework. And imagine explaining that to a judge and litigating that. So it hasn't been litigated yet, but yes, an arbitrator who has experience with NIST would be much better at that.
I have to make a plug, because so we did this cybersecurity protocol for arbitration, which everybody should take a look at if you haven't. It's really, and we spent a lot of time with the NIST standard. It's interesting, actually. It's actually quite accessible for such a technical document, I think. I find it. Yeah,
but what reasonable conformance to it is
right. Well, that's the thing.
Yeah.
That
No, but you're right. For engineers, they did a good job.
They did a good job.
So we've only got about 4 minutes left. I want to invite questions from the audience, remind them, and really pause for a second just to see if we've got some. And if not, I'm gonna return to the one I promised to earlier. And actually, why don't I do that while we wait to see if we get some more? But the question was talking about the different standards in the U.S. And Europe. With the different and several protocols, is there a chance to create a global platform to work towards more unanimity in consumer protection worldwide? And would this be feasible? Thoughts on that? Are we gonna get? I mean, Kathleen, you raised an interesting point apropos of this in our planning call, that the rest of the world is sort of looked to Europe, or much of the rest of the world outside of the U.S. and some other countries.
For data protection, I think that's...
For data protection.
Yeah, for data protection. So, I mean, the history here is that the Data Protection Directive, 1995, the scary thing is that I actually lobbied the Data Protection Directive. I don't like to mention that, but it's a long time ago. Then that directive really formed the basis for, I think it's like 50 or 60 laws outside of Europe. And that is the core of the GDPR. The GDPR did not change much from that data protection directive. It's really surprising how many countries have GDPR-like laws. And the other way that the European Union is very good at exporting its data protection laws is through, it won't sign a trade agreement now unless you agree to be an adequacy country. So, and that means you have to adopt a law which is substantially similar to the GDPR. So Japan just did it. South Korea's in the process. I mean, they're really to say they won't sign it is a strong statement, but it's certainly part of a big factor in the negotiation over trade deals is whether you're willing to become an adequacy country. So for example, Canada is, but only for commercial entities, but Canada is adequate. So data can flow freely between commercial entities in Canada and the European Union, unlike the United States. So but that isn't on the consumer protection front. I think there's such, I mean, consumer protection, I think it's important in both places, but it's much stronger in Europe. So it would be hard to imagine the US going to that high a level, but who knows?
So we've got a minute and a half left. I hesitate, but I'm going to do it. Well, actually, let's do this. Let's do closing thoughts on any of these issues. But our last question are advantages or disadvantages of including an arbitration clause for data privacy breach issues versus relying litigation process. Feel free to address that or some part of that or any of the other issues that we've been talking about. And Chrissy, why don't we start with you?
Just putting me on the hook there, Brian.
Yep, I am, but you can handle it.
I mean, my closing thoughts really are that it's going to be interesting to see the development going forward. To the last question we just had, not the one you just mentioned, about will we have a worldwide privacy initiative, referendum, et cetera. I don't see that, but I do see more privacy rights for consumers, and also tighter controls for data transfer between B2B as technology gets bigger and as our legislators get smarter on wanting to provide more rights.
I'm going to cut you off. Sorry, just to get Steve and Kathleen real quick. Steve, 10 seconds.
I agree. It's never going to happen on a global scale. It's culturally too different in terms of innovation here in the United States. And then on the contracting side, what's just as important as your terms in your contract is diligence afterwards. Don't just sign your contract and walk away.
Perfect.
Monitor
Diligence,
and audit
Kathleen.
your service providers.
5 seconds.
Cut us all off.
Arbitration in the B2B context, that's for sure. B2C, I think it's much more difficult in Europe.
Excellent. Well, thank you. Yes, this was a great conversation. And Kathleen, again, thank you so much for joining us at such a late hour. So, and thank you to ASIL for organizing us. I had a lot of fun, and I think the rest of us did as well.
Absolutely.
Thank you, Brian.
Thank you, everybody.
Thanks, ASIL.